Okay, so we're not gonna spend any really much time at all going over the NAR settlement. By now, I think everyone has a general idea of what is required. Although I saw a presentation by a FAR lawyer, and he said that he had 168 voicemails the day that they rolled it out, asking, what is this? Or I thought surely there would be an extension. There's not an extension. It is officially supposed to have been accomplished by August 17th. Our MLS chose to roll it out on the 6th, which I hate because I think we might have lost some good buyer opportunities, but they wanted everybody to have an opportunity to get familiar with it, how it works, ask all their questions before the 17th, where you have to use it and have to use it in a way that complies. So what we're going to do today is we're going to go through the exclusive buyer broker form that you should all be using. The form number, so you can write it down, please, is, and if you can put this in the chat, Eliza, EBA-7B. And make sure that you're using the July version. That's the code to find what you need on Form Simplicity. The one that I just gave you is an exclusive buyer broker agreement that is intended for those of you who work for transaction brokers, which is most of you on this call. So this will be the form you use. Now, I anticipate some buyers forming their own buyer exclusive representation, and they would be single agent. And so some folks are trying to go from single agent when you first begin to work with the buyer. And if the buyer is going to sell property, buy property that they already have listed, then transfer to a transaction broker relationship. But that's all I'm going to say about that. If you have more questions, or your broker that you work for is not a transaction broker, reach out to me and I'll give you those forms. All right, without further ado, anybody have any questions about that before we actually start going through the forms? All right, I want you to raise your hand if you have a question.
No, unmute.
Alyssa will be asking the question. Alyssa will be watching the chat and will be letting you know what the questions are. And this really works better if you ask me questions as I go along, because if you have a question about something that I have said, I have likely confused not only you, but others. So you don't have to wait to post your questions until the end. You can just raise your hand as soon as anything that I say. When I'm done, I'm excited to let you know we have Armando Tautiva here with us today, who has been a lender in this community for more than 20 years, something like 30 years, I think, but he'll let us know. And he's going to talk about what he knows from the lender side is happening with VA, FHA, and Fannie, and how some of these concessions or language we're going to use in these contracts to accomplish what we need. He's going to talk about how that works. All right, without further ado, I'm going to share my screen, and what you're going to see is our new buyer broker agreement. Okay, so tell me when you can see the buyer broker agreement and not me. Fabulous. Okay, so we're going to take a little time to go through this, folks, because I want to make sure that there is a clear understanding of all of these. And some of these, while they don't immediately look to be important, they really are. So let's go. The first thing I want you to note is they're not using the word buyer anymore. They're using the word consumer. And that is their way to make clear that these rules and the layouts that they're talking about also cover tenants. So the second thing to note is that the broker is the broker, but it can be the broker's agent. So you would put Leslie Weichman, associate / broker, whomever they are. And if you're on this call and you are a broker, I suggest that this be a time that you start taking a little closer look at these forms to make sure that they're being filled out correctly. Now, FREC and FAR have taken the position that they are not going to be auditing your files, looking for compliance with this rule. They're not going to have you send in one for every transaction you do. According to FAR and FREC, the only way you would get quote unquote caught if you weren't using this form is just by a regular desk audit that you guys are familiar with when they go into a transaction and make sure that you have all the proper forms filled out for that transaction. Now they're going to be looking for this. The MLS has taken a different position. They've taken the position that they can, in fact, get in your files, and they say they will be doing this to ensure compliance. So either way, we need to do and use the right form, which we need to understand. All right, so we talked about the first change, that it applies to quote consumers. Now let's talk about, and in that definition up here in 1, please note that the broker, which is the associate generally, has the right, exclusive right, to work with and assist the consumer in locating and negotiating the acquisition of suitable real property as described below. This is really important. The term acquire or acquisitions includes purchase, options, exchanges. An exchange, which happens sometimes very infrequently, is when someone says, I'm in A house, you're in B house. I will swap houses for you plus $20,000. Believe it or not, we occasionally do see these. All right, the term, section 2. This is very good. It makes it clear that the agreement will begin on whatever date you put in here and terminates on 11:59 p.m., which is a little bit different, on the whatever date that you put as the termination date. The consumer later has an opportunity to cancel early, and we're going to go into that. But you guys are somewhat familiar with this section because it is in something like it is in your listing agreement. Section 3 property is where you need to be careful. There is nothing that prevents a buyer, consumer, from having buyer broker agreements with 5 different buyers, 10 different buyers, 2 different buyers, however many buyers, brokers they want to work with. They can sign an exclusive with all of them, but it's going to be bound to the property. For example, if you want to look at one house and it's located at 123 Main Street, your buyer might want you to put 123 Main Street as 3B, and that is then the only property that they have an exclusive with you. I prefer, and again, when I say I'm a lawyer, I need to say this, and you'll hear me say this a few times. You have to do what your broker says. And if I say something different than your broker, have your broker call me and I'll explain my position. She'll consider her position, and then she may change her mind. But I'm not your broker. As y'all know, you have to take direction from your broker. But if I were the broker, I would want A and B to be as broad as possible. Because if it's broad, they can't do something else with another buyer unless it's outside the scope of what is in 3B. For example, if you put the type of property, a single family residential home, in location to protect yourself, I would put Orange County, Lake County, Sumter County, Seminole County, basically any place that is you're willing to go. If you had put Lake County here as an example, then that buyer would be free to work with another buyer's agent in any other county. So I like the type of property being a single family residence, because we don't know ultimately what they're going to want, but it has to be at least a 1 to 4, which is the only property status that these apply to. I like to see type of property simply single family residential home, if that's what they're looking for. Does anybody have any questions about this and how this might impact your practice that we have this type of property and location here. Any questions on that? You can either raise your hand, unmute yourself and shout out.
We have a question from Tiffany. Can you put TBD on the form?
No, the problem with TBD is you don't have a contract. Think of it as a legal contract. Without the essential terms being in the contract, it is unenforceable. We would not do TBD here, and I'm going to tell you why a little bit later in my presentation. There's a couple reasons not to do TBD, but you can't do it. It has to be enough that we can be enforceable, which means it has to have terms that are at least reasonable. So it needs to be type and location. Any other questions?
Yes, MLS, single family residence is a separate category to mobile homes. So is single family residence going to be considered a mobile home, or do we have to distinguish that as well as a type of property?
It will apply if the mobile home is used as a residence. If the mobile home is used as a commercial property, as a rent B, something like that, no. But if it's going to be lived in as a residence, this applies, but not above the 1 to 4 that you guys are so familiar with. Thank you for correcting me on that. I was speaking of single family residences the way that we do as lawyers. Any other questions about this property section? I would really encourage you to make this as broad as possible to protect you. Because that way, if they go and see another property in Sumter County, if you're just looking at single family, looking for residents to include mobile homes and stick-built homes, be as broad as you can. Because if you put, for example, Seminole County, and they go and buy property in Seminole County, you're going to have a claim because they had an exclusive agreement with you as to Seminole County. If you neglected to put Orange County, then they would not have you would not have an exclusive as to anything in Orange County because you have not named that as one of the property locations. Does that make sense for you guys? Any more questions on that issue? Because I think we really need to get this right, and you need to really do as much to protect your exclusivity, the range and the size of your exclusivity as much as possible.
We have a question from Cassie. What if buyer is working with other brokerages? How will they know if they are working the same properties if it is so general?
So first of all, the buyer, I'm hoping that the other agent is smart enough to ask, are you working with another broker, which is completely reasonable. Can I see a copy of that agreement? And if you pick up if you get a copy and that it covers Orange County and you want to show them property in Orange County, you're going to know if you try to do that, you're going to put yourself in a bad spot and unlikely to be paid for it because of the nature of this exclusive agreement. Did that answer your question, Cassie? I hope. I know you can't talk. If you need further elucidation, please put it in there because that's helpful to everybody.
We have another question from Carolina and Nancy, kind of the same question. Can you put the location as Florida?
I suppose. Nobody's interpreted, there's always a principle of the law that says something like an agreement cannot be unreasonable. I don't know yet. A lot of this is going to be developing as FAR and NAR figure it out. I might be hesitant to say Florida unless it really as a routine, but I'd feel more comfortable if you said Florida, if you were working with a buyer that was looking at houses on the water down in West Palm Beach, and then they also want to see some houses on the water in the Panhandle, and then maybe look at some things in Jacksonville, or they just want to view all beach communities as an example, and are willing to move anywhere. In that situation, you could use Florida, but you might get yourself in trouble if you put Florida there and are dealing with a buyer's agent that you know only wants certain locations. Does that make sense?
And then I've got another question from Liz. For type of property, can we put any/all types?
No, and that doesn't even really make any sense because this does not apply to commercial property. It does not apply to any properties outside the 1 to 4. It does not apply to vacant land. I would be concerned. I think what you could do to protect yourself in this situation, if you're working with a buyer and you know that he's looking for a home, then I would say something like a residence for my family or for their family. But I wouldn't do everything all. Again, there's the old pigs get fat and hogs get slaughtered. And that works in the court system just the same. So I'd be hesitant to use, again, that would be so overly broad. If you knew your client was really looking for a home for their family, I would put single family home.
Okay.
Does that make sense?
Yes, and then we have Cassie again. She asks, so we can't ask agents to see other buyer agreements. Or excuse me, so we as agents can ask to see other buyer agreements.
You need to ask, and in the spirit, it would help him to know what your buyer's agreement looks like. So I would say, I don't need to see your percentage compensation, and I'm not going to show you mine, but I do want to see the parties 1 through 3, black the rest out, and I will give you mine the same way to see if we have competing areas. Because they don't want to compete either, right? Because if your agreement was first, then they're just wasting their time. Now, I realize you might not know a person to ask because usually these buyers are sneaky pete's and they don't tell you who they're working with first. If they work with someone else in Orange County on a residence that in this scope of area that you have put forward here on section 3, then you're the one that's going to get paid as long as yours comes first. Does that make sense?
Yes. And then I do see that Vivian has her hand up.
Vivian, shake your mic.
Okay, hi there. Yeah, let's go back to the Florida. Can you put all of Florida? Being an NAR director, you would be doing your buyer disservice if you put all of Florida. So let's say I live in Central Florida and you want to go show a property in the Panhandle. Are you going to drive 8 hours to go show that property? We still have to be considerate and making sure that we're working in the area that we live in. I would say maybe an hour and a half out, but not 8 hours out. Being NAR director, they're saying that don't do that because you're doing your buyer disservice by putting all of Florida. And keep in mind, if you do have an investor is not going to sign an agreement. He's going to sign an agreement with you in every area. He's not going to sign one agreement because he might be looking at different property. He might be looking in the Panhandle. He might be looking in Miami. And you're actually not driving to those places in order to show those property.
Although you might, if it's got a price point that's worth it, I would shag my butt down to Longboat Key to sell
Right.
a $6 million condo.
I would too.
And that was my example, Viv, about if it's work that you're actually going to do, then you're fine. If you meet some rich buyer and he says, I just want to, then it would be fine. It's unreasonable when your buyer has actually told you that they need to live close to their kid's school, they need to live close to their husband's work, whatever that situation. Pigs get fat and hogs get slaughtered, right?
Yep.
So be reasonable, but you can also react to the specific. Make sense?
Thank you. Yeah. Thank you.
Okay, so now any other questions, Alyssa?
We actually do have a couple more. Liz Turner asks, do you sign a buyer broker agreement with the buyer to then be able to refer the buyer to another realtor who you work with in another area of Florida?
FAR has not come out on a position about using cooperative brokers in other areas. I don't see why you couldn't, so long as you properly paid from your money you agreed to pay under this agreement, which we're going to go through. As long as you're paying it like a referral from your amount, I don't see anything wrong with that at all. NAR hasn't said there's anything wrong with it at all, certainly. And you have to understand, the settlement terms are very narrow. NAR and the MLS NARFAR and the MLS have taken a very conservative interpretation of the rules of the settlement agreement language that I would not have taken, but they have, because their primary purpose is to protect their entity from further suit. While they say in somewhat are interested in you guys, of course, their primary interest is for them themselves to stay out of trouble. Does that answer your question?
And then I'm going to combine two questions from Carolina and Cassie. Carolina asked if maybe she could put one or more county in the location, and then Cassie was asking if maybe it was a good or bad idea to put a full address.
I wouldn't put a full address unless you have what we essentially what we used to call a showing agreement. If they know that all they want to see is 123 Whole Road, then put that there. But the danger of that is, you know how many times a client thinks they want to see 123 Whole Street, but then they don't like it so much, and then they want to start seeing other things in the immediate area. So that's what would concern me about getting outside of a larger city, larger several counties. Again, if you put 123 Main Street, completely legit, but that's not protecting your practice in the way that it could if you made it more broad. Now, remember, this is a negotiable document, right? You might put broad counties and just say type of property, single family home, including mobile homes. They might say, I'm not going to sign that, but you just don't know. And then you wouldn't have an agreement, obviously. Anybody else?
Yes, we have a question from Noel. So does this form protect your procuring cause status?
It does. So procuring cause is always, you guys know how that's looked at. But if you are not the procuring cause, in other words, if your customer has cheated on you, we're going to go down here and see some of the terms that provide you guys protection that you need to understand. So that more will be revealed on that question. Hold tight and we'll get you more info.
Okay, and then we have one last question from Gigi. And how do we utilize this concept at open houses? The agents need to show up with clients now.
No, I was going to talk about open houses later, but I think it maybe makes sense here. We've gotten lots of inquiries on open houses. So let me tell you a couple of things. There is a rumor running around that you have to have two, if you want to advertise your open house in a realtor only section or any other section, you wanted to say open house Saturday, right? We already know you can't put anything actually in the MLS, even in realtor only remarks, about what the commission is going to be. We already know that question has been answered. So some people have started this, I don't know, they say it on the internet, so it must be true, that to protect yourself, you should have 2 clicks away for them to be able to find the information on your website. Because what you're trying to do is be seen to be not using the website. So some people are taking the position that if you say in the realtor remarks, open house, and then have a link to, for example, your open house flyer that might say, my seller is offering commission, right? They would say that's 1 click away from the MLS to get the information. Some people are saying it should be 2 clicks. The first click being to your broker's website, and then the second click being on the particular property. I don't think there's any need for 2 clicks. You can do as many clicks as you want, but it at least needs to be a click away. You cannot put it in the realtor remarks, but remember, you can put it anywhere else you want. So that's going to be up to you guys. There are some brokers that are going to have their sellers offer none until they get an offer. Just say, we're not advertise that they're offering anything and wait and see what comes and then make the concession at that time. For the same reason, a lot of buyer's agents are suggesting that you make those offers even if the seller has not disclosed in any way. Even when you call them on the phone, the agent says, I'm not allowed to give you the commission amount, but please bring an offer. And in that offer, put your amount that you want, which is going to be the amount the buyer owes you, which we're going to go through in a minute. Does that answer your question? I hope so.
All right, we are done with questions for now.
Okay, great. Now let's go on to section 4. The broker obligation is exactly what you would expect it to be. That's the stuff that brokers do. They all do to get something to close. But I want you to see subsection B. Consumer understands that broker may work with other prospective consumers who want to acquire the same property. So that would mean other brokers, agents, customers who want to access the same acquire property in Lake County, if you put that as the location. If broker submits offers by competing consumer, broker will notify the consumer that a competing offer has been made, but they say will not, I say cannot disclose any of the offer's material terms or conditions. So in other words, you can't work two deals against each other. You can't tell buyer 1, hey, buyer 2 just offered 7,000 above yours. Do you want to come up? You can't do that. You can't give no specifics about any of the terms of the loan that you might know about, nothing. You can't disclose that any of the material terms or conditions of the other. They can make competing consumers aware of the existence. Again, what we just said. But again, you cannot reveal any material terms or conditions without their written consent. Fair housing, y'all already know about that. You can't let anybody tell you, I only want to look in neighborhoods that don't have Muslim people, for example. That's still against the rules, as it always has been. And they've added in this section D about service providers, making it crystal clear that any person that you recommend, especially for bug, what do they call them? Bug and something. The home inspection, the mold inspection, and the bug inspection, you're not responsible for any of that. Any third party you recommend, a lawyer, accountant, anybody, you're not going to be responsible. Any questions about that?
WDO.
Thank you for reminding me. That's the term I was trying to think of. Any more questions about this section? And working with other consumers? Okay, seeing none, let's go down to the consumer obligations section. These are the things that you would expect: conducting all negotiations, referring brokers of any kind from real estate licensees, property or other sources, consumer contacts, or is contacted by an owner who's working with an owner, or views property accompanied by broker. Consumer will, at first opportunity, advise the owner of real estate licensee that the consumer is working with and represented exclusively by the broker. So they say all of this to say that the brokers can work with other people, but you, the consumer, cannot, as to a property that falls within, by description and location, what you have put in the property and location section. That would be a violation of the terms of this agreement for them to go and work with someone else in the same areas for the same kind of property. Again, it's putting I've highlighted here. The other things are being available, indemnifying and hold harmless, not acting or expecting to restrict based on our fair housing and discrimination categories. You can see then. And then it again makes it clear to them that they have to talk to legal, tax, environmental, engineering, foreign reporting requirements, FERPTA, and other specialized advice, which would include zoning, land use, property setbacks, whether their house can be built on that specific property. None of those things are you responsible for. And in fact, none of these should you gals be doing anyway. You should not be given FERPTA, legal, environmental, other things like that is specialized outside of your area. You should not do that, and you should direct them to do that. And I know many of you try to do it just because you want to be helpful. And I love that, but that's typically where people get sued, is when they're just trying to be helpful. Most people aren't bad people. All right, I've had lots of questions about section 6, which is a retainer. This is something that I think you should bring into your practice, because this, for the first time, is an amount that would at least give you some money for the fact that you talk to these people, you get their info, you figure out what they're worth, you pull up MLS, you send them you do a good amount of work. If they pay the retainer, that retainer is released to you immediately. In other words, it needs to be signed, it needs to be provided when you sign the agreement. And don't feel bad for asking for these retainers, because how many times have y'all worked with a buyer and they couldn't find anything, and you shagged around and drove them all over Kingdom Come, and you've got nothing to protect yourself? So really do talk to your broker about these retainers. Now, to make your consumer more comfortable, you could say, if you buy, I will apply that retainer amount to my commission, although you don't have to. I would start out with this being a reasonable expectation on every file, because after all, it's here. And we know that when we know that somebody's talking, I can hear. We know that, I lost my train of thought. Oh, we know that we haven't used these in the past, but things have been different in the past, and this is just an extra protection. Let me see who's accidentally unmuted. She sounds like she's got a little baby. Or me.
It's like Bonnie's.
Can we see who it might be?
I think it's Bonnie's iPhone.
Bonnie's iPhone.
Sorry, guys.
Oh, no apologies necessary.
I'll turn it. I don't know what happened.
It's okay. Most of us have kids and we know what it's like. Okay, so that's it on the retainer. Please consider using it. Talk to your broker. Do we have any questions about how the retainer works?
Nothing in the chat right now.
Okay. So let's talk about compensation. This compensation to be earned has to be a dollar amount or a percentage of what the purchase price will ultimately be, or a dollar amount or a percentage plus a bonus, right? So you've got dollar or percentage, or you have dollar, percentage, and bonus. That's a neat little thing that I want you guys to consider using. I hope the whole industry considers using them so it becomes something that's normal, because sometimes you don't know how much work is going to be needed on any particular file based on how difficult that property is. If it has 100 bunch of problems and you have to run around from here and there and everywhere, you might really need that bonus to be fair. And again, you have the right to waive that bonus, especially under those circumstances that maybe you just took them to a brand new house, and in a subdivision, there wasn't much they had to do. But do consider the bonus piece, especially if somebody says they want to buy a fixer-upper, something like that. And that percentage is going to be the total purchase price, and it's going to be payable no later than the date of closing. However, closing is not a prerequisite for broker's fee being earned. And we're going to tell you a little bit more in the form later what the heck that means, why they divided it into two places, I don't know. So that money's going to be due, generally speaking, even if the properties don't close, which I think is important to know. There is the lease. This makes it clear that these do apply to leases. And you can see that you have the same options there, money or percentage plus some amount, or just money or percentage. And it's going to be the gross lease value is what I would want you to choose here. I wouldn't want you to do month's rent. That's not going to be enough. The gross lease value means if it's $2,000 a month rent, it's $24,000 as the gross lease value, which means you'd be getting your percentage of $24,000 instead of $2,000. So I see no reason why you would not choose gross lease over month's rent. All right, and that again is payable when they enter into the lease. So lease is signed and you get paid. Okay, option agreements. I am seeing these used more and more. I want to caution you about the way these are being done. If you work with a lawyer-owned title company like myself, we will help you with it to really create lease option documents that really do what they're supposed to do. For example, being able to prevent the purchase and exercise of the option if they have not followed every term of the lease itself. And there are other things that we would want to put in here that would trigger a seller not to let them occupy, excuse me, take advantage of the option unless all the circumstances are made or occur. Finally, the broker is compensated for all types of transactions, which we just talked about a little bit earlier, people exchanging property, all the things they talked about here. They're just trying to give a catch-all. If it's another type of acquisition, your percentage is going to be based on that acquisition as if it were a purchase. For example, if there is an exchange of a $200,000 property, you represent the buyer. Your buyer gets a $200,000 property and has to pay an additional $50,000. Then your percentage is going to be based on that $250,000. Any questions about section 7? Obviously, there's an additional fee section, which you can be as creative as you want to. $25 a property in excess of 10 has been shown. You can do whatever you and your broker think is reasonable here. As long as it's signed and agreed to by the buyer, it's okay. So think about that as you think about the retainer fee. Now, I love the protection period. So even after this agreement expires, they can't, if they go and acquire the property, and here it is defaulting to 30 days. But if the property gets acquired within this dates that are here, you are the one that's going to get the commission. And that's going to be a potential for a dispute if they've been working with someone else. So here again, one of the things you're going to ask them when they come into your door is, are you working with someone else? If you find that someone else picked up the deal and got it closed, then you have a right to see the date of their agreement and the scope of their agreement to make sure that they are not interfering with your exclusive relationship. Anybody have a question? I will say while we're waiting for questions, based on the nastiness that I see happen here, people going, and I typically see it as people going around the agent and then dealing directly with the seller on a property they've seen. Do not limit it to 30 days. I'm just going to tell you, we see this kind of bad behavior happening more than 30 days after. I don't think that's enough protection. You get with your broker and see what he or she would prefer. If it were me and I was a lawyer for the buyer, I'd want to see something more like 120 or 180 days. Because they are sneaky and they're going to be even more sneaky trying to get out of these fees.
We do have a question from Carolina.
Yes,
I'm not sure what section she was referring to, but she asked if it's legal to add any language to the additional fees. For example, if the seller is paying 2% and we added in the BBA 3%, can we change it back to the 2% the seller is paying?
okay, good question. Whatever, it's really two questions. First of all, whatever is the percentage in this agreement, whatever source that money comes from, this is the maximum you can get. So if you say, an example, purchase is 2%, you tell them I'm only going to charge 2%. And then sadly, you find out that the seller was actually offering 3%. You cannot get that extra percent from the seller. You are stuck with the percentage or amount that you started with. Does that answer your question? That first question?
Yes.
Okay, and for that reason, you cannot put in additional terms, maximum up to the amount the seller is offering. And I can see why you would think that's a good thing to do, right? But it's not. It's very clear that you cannot move beyond the percentages as to the purchase. Now, what you could put in the additional terms are the things that I just talked about. The buyer recognizes the time and cost in showing you more than 10 properties. So any property I'm showing you beyond 10, I'm gonna have to charge you $25 extra. That's something that could be in the additional terms as an example. Does that make sense?
Got a yes from her. And then we did get feedback from Vivian if we could use Apple versus percentage.
If you could do what?
If we can use apples versus percentages.
Okay, so I don't know where this Apple idea came up. I hear this Apple thing a lot. Where I generally hear it is, for example, at an open house, putting 3 apples up on the bar to make clear that you are offering 3% commission. First of all, you don't have to do that because remember, when a seller is advertising commission, he can still put it anywhere except the MLS. So it can be on your open house flyers. It can be on your website. You can text or call or email with realtors about what you offer. All of that is still 1000% legit. So you don't have any reason to put something like 3 apples. Would there be another, Vivian, another reason you were thinking of 3 apples?
No, Meredith, I was taught when we're inside of a conversation, we should not be discussing percentage. So that's why I'm saying, instead of saying 3%, we're saying 3 bananas or 3 apples.
In a conversation with whom?
In a group of people.
Remember, you all, if you and 5 of your realtor friends want to host a broker open, and you want to tell them all, each of you tell them, hey, we're offering 3% on this property to the buyer side. That's totally legit. Whoever told you that you cannot discuss what you can't discuss is, of course, setting commission, but you can get in a group and discuss what everybody's offering. You can call someone up and say, how much commission are you offering? You can do all of that legitimately, Viv. The only thing you cannot do is, number one, don't show them a property that they want to see just because you called up Matt Wheatley and found out he's not offering commission. You still got to take them, right? You can't be discriminatory, and the settlement agreement says that specifically. You can't just show them properties where the seller is offering commission. But you can discuss commissions with your fellow realtors. If your client wants to see 6 houses, there's nothing that keeps you at all from calling up each of those individual realtors and asking how much they are offering on commission. So there's no need to have to discuss bananas and oranges. I don't know where that's coming from, but it's not true.
Okay.
Yeah.
We got a.
And do you understand? Hold on. Do you understand, Viv, why it's not true? Considering what I just explained to you, that you can advertise and talk about The
Right,
commission,
you just can't fix it. You can't talk about fixing it.
that's
In a
price
group of,
fixing,
in a group of
right?
realtor, right?
Right, you've never been able to do that. You've
Right.
never been able to say, hey, let Keller Williams, let's all of us never back down from 4% commission. That would be antitrust violation, whether you called it bananas or apples or anything else.
Correct.
Okay.
Yes.
Any other questions? This is what I
Yes.
was hoping this call would be, to help really get at some of these specific questions. Any other question before we move on to termination?
I got a question from Cindy. I'm not sure what she's referring to, but she asked to please provide examples of when working with a builder, but I'm not sure in what context.
I don't understand that question either. Builders can offer commission, and if they do, it's treated like any other situation. You can call the builder and say, builder, what can you offer to help my buyer be able to buy this house, because we've got this blah, blah, blah buyer's agreement? And they can say, sure, we'll cover it for him. What they can't say is, we'll cover it for you plus an extra $500 if you'll bring some more buyers around. Because remember, the rule is you are stuck with the amount in the buyer's broker agreement. You can't get more just because you're working with a seller who offers more, whether it's a builder or anyone else. Did that answer the question?
Cindy, she says almost under contract, but the buyer will not sign.
Oh, this is a good one. I have this question asked of me a lot, that the buyer, what do I do if the buyer won't sign this? The reality is this: a buyer's broker agreement does not have to be signed until before you cross the threshold of the property. What that means is, before you take them into the first house, you can send them video, but you can't take a walk through yourself to show to your potential buyer exclusively, because that's obviously acting like a realtor. But you can send them MLS sheets. You can send them videos that the seller prepared or that you prepared for another buyer if you're a buyer's agent. You just can't say, hey, Johnny, I'm going to go in the house and make you a video to send. That would be crossing the threshold electronically, which you cannot do. Do y'all understand the distinction? If you're just sitting there passing out stuff to them that's already available, MLS sheets, videos already created, you don't have to have this signed. But you can't actually show them a house, even if the showing is by video, without this document being signed. So the reality is, if they won't sign this document, you cannot work with them unless they want to buy a house based on videos created by a seller. And then you can't do all the things that you would normally do to take them through the transaction without that buyer's broker. Once you cross the threshold, digitally or physically, you must have this signed before you show the property. Does everybody understand? Any questions about that concept? Because I have a related concept to talk about, but do you have questions about that concept?
We do have other questions about the commission portion.
Yeah, that's fine.
So
Go
we
ahead.
do have a question that I think would help answer Marilyn's question and Karen's. Karen's is, if you put 5% on the EDVA, but the seller is offering 3%, can you drop the other 2% and not make your buyer pay it? Sometimes we get more commission on a lower priced property or on a land deal.
Okay, excellent question. You could always waive these numbers. You could take them to see one house in one neighborhood that's a platted subdivision that you know is not going to raise a lot of problem, and they're almost there, and you need to waive a little bit of your commission. You can, but the consumer cannot. The consumer can't just arbitrarily, now they can go back to you and try to renegotiate, but remember, then we're back to the section of the agreement that says it is your choice whether the agreement is going to be changed or done away with entirely. That is your choice. They can't force you, but you can also make the independent choice If you want to give them a break so you can get the deal done, or because you thought it was too easy, it's something makes you want to give them a break, you can do that, but they can't force you to do that. Does that answer the question?
Yes, I believe we're done with that one. The next question we had was, are we able to earn a bonus outside from the buyer broker agreement?
Are you able to add a bonus outside the buyer broker agreement?
Sure.
Earn a bonus outside. The terms of the agreement are supposed to lay out everything that you have to do the deal. There is nothing that would prevent a buyer from saying, hey, you really busted your butt on this one, and I really appreciate how you handled all these inspections and blah, 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 blah. I really think that you're due more. They can do that. Absolutely. And they could do it as a bonus. You just can't demand it because your contract doesn't have that bonus in it. Does that make sense?
Yes. And then we have another, it says from Nancy, can you do an addendum changing the amount of compensation?
Yeah, so as all contracts can be addended if they have a proper amendment. And here's where you're going to be working with a lawyer-owned title company like mine, because the amendment has to be done really with lawyer language. Y'all are used to saying extend closing by 7 days. If we were going to make an amendment to this agreement, it would require a lot more than that. You could also, just to make it easier, have a new buyer brokers agreement, cancel the old one, and enter into a new one. That's going to be your best bet if you can make that happen. If you can't, you can do it with an addendum, but the addendum has to be properly written. Does that make sense? I can't see people's faces, so I don't know if I keep saying, does that make sense? Because I can't see faces, so I don't know if you guys are still looking confused or if you're looking, okay, I understand it. Shout it out.
We got a yes from Nancy, so she is good on that one.
Okay.
Next, from I think it was Camille. She asked, I think about that virtual crossing threshold. She asked, how about when we do a Facebook Live? Will that count?
If you're doing a Facebook Live, as long as it's out to everybody, then no problem. You're just marketing the property. The moment that you send that Facebook Live or tell a person that you are considering working with, watch this Facebook Live, then it starts to look like you're acting on their behalf. I think the easiest way to understand it, and this is why at the open house, that we have to remember that the seller, the person, the realtor at the open house doesn't need a buyer's broker agreement to walk them around the inside of the house because they are working on behalf of the seller. A Facebook Live that you just generate is working on behalf of your larger community because you're a buyer's agent and you want to have people find it, or it's your own listing and you want to have people find it. But the moment that you send it to John Schmo, who you're working with, that's where you can get into some trouble. Now, I could try to defend you and say, hey, that was just like sending him an MLS because that was already created. I think you'd get in trouble for it. No, but I think it's a really gray area because you are using video and directing it to them, for them, I should say. But as long as it's not directed for them, you're okay. As long as it's something you're doing as a general way, you send to them, you're good. It's why you can send to them a video that's already been created, but you can't say, Joe Blow wants to buy 123 Main Street, so I'm going to go in and I'm going to do a Facebook Live for him and everybody else. That would be a violation because then you'd be acting like his realtor, his specific realtor, by going and taking the video. Does that make sense?
I'm waiting. Yes, Camille
That's
says,
not
thank you.
This brings up, we're going to take the next question, but I want to make the point. This brings up something that I'm asked about a lot. What happens, because we know this is going to happen, when the buyers call me, the lister, directly. First of all, if that buyer has an agreement with you, he can't get around you. He's gonna owe you under this agreement, even if he thinks he's doing something cute by calling the seller directly. But some buyers, when presented with the option of paying the commission on their own, might say, I'm not signing this agreement. I'm just gonna start calling all the people that I see on the sign. Then the question is, what does the seller need to do? Does the seller need to enter a buyer broker agreement with this guy? FAR has taken the position that you can work with the buyer on ministerial issues, such as helping them fill out a contract. But when you also then drift into acting like their realtor, representing them in the closing, ordering up their inspections, then you've moved out of ministerial work for the seller and into acting like a buyer's agent. And at that point, you would have to have a buyer broker agreement. But if they just come to you and they just want to fill out the contract, then you don't have to have an agreement with them. Now, you and I know that hardly ever do they just want help filling out the contract. I don't know how you would get it to close without helping that buyer figure out what to do, unless maybe they had a realtor working with them or their brother or something like that, helping them understand. In limited situations, sellers agents are going to be able to do ministerial acts such as draft a contract on behalf of a buyer without having to have a buyer's broker agreement. But as soon as they start showing them other properties, or as soon as they start acting like they're representing them in the transaction, then they have to have a BBA. Does that make sense to everybody?
We have another question from James. It says, what if you agree to 3% with your buyer, but the seller is only willing to pay 1%? Can you get the difference from the buyer?
Yes. So just like they are bound by the terms of blah, blah, the other things here, I'll only buy property through you in Lake County. Similarly, if they agree for 3 and the seller is paying 1, you have to take that 1 that the seller is giving you and apply it. So now they only owe you 2, but they do absolutely owe you that amount. And this is a valid contract. So if they try to go around you or refuse to pay that amount, you can sue them in court like any other breach of contract action. Now, the commercial world, our commercial statutes allow any realtor who feels like their commission may be at risk can actually file a lien for commission. I am hopeful that after these rules are more fleshed out, after we've had some time to see how it works, after we realize how many buyers brokers are getting screwed, I'm hopeful that the legislature will change the statute to apply to residential as well. But I think they made the decision that they wanted to make things easier in a residential market and don't allow us to. Having said that, I am giving my realtors some tips and tricks there to try to help protect their position as much as possible, which would include, for example, in the additional terms, adding a term that this agreement can be recorded. Once the agreement is recorded, then a title agent will not close the transaction without resolving this issue. They theoretically could close around it, but the underwriters will not let them. They're like, I'm not buying a lawsuit, blah, 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 blah. It can't close unless that buyer's agent gets the full percentage the seller wants or proof that the buyer is going to be able to pay them. Does that make sense?
I will wait for James's response. I did get another one from Shirley. She was wondering about the builder side. She said a builder told her yesterday that the buyer's agreement does not affect them.
I have no idea why they would think that. The only thing I could think of is maybe they're not in the MLS.
And we do have one from Diane on that same subject. It says, what if a builder offers a bonus, like if one sells multiple houses to them?
That would depend on how it was done. If it was a bonus for that, if it's a bonus that is regarding a property for which you have a BBA, that bonus has to be applied to the overall amount that the buyer would otherwise get. In the same way, if a seller is actually offering a concession, that has to be applied to what the buyer would otherwise owed. So what they're trying to do is make it clear that the agent is never going to get any more than what the agreement says. But if you like to work with a builder who is going to pay you $500 per house, then you could put that $500 in that bonus section. And then instead of making the buyer pay it, the same rules would apply. So what the seller is paying would satisfy that $500. Does that make sense? And if you're going to be working with a lot of, first of all, I want a lot of people putting this bonus in, because remember, you can waive it. And especially if you're working with a builder or some similar organization that is going to bonus you in addition to whatever commission that they're offering. To keep you protected so that you actually get that money, you would want to put a bonus in that portion that I have highlighted on 7A.
I have another one from Noel. He says, so this is really the mirror image of a listing agreement, correct? What if the buyer does not want to see property where no commission is offered?
Okay, this is perfect. It is much like a listing agreement. No, you're absolutely right in terms of a lot of the protection period and how compensation is determined. Yes, that's like a listing agreement. What was his second question? If someone only wants to see property.
Yes. What if the buyer does not?
That would be something. Okay, excellent question. No, the settlement agreement says you cannot work behind the scenes, find all the listings that are offering commission and only show those. You can't make that decision. However, your buyer can, and the buyer can do so in the guess where? Additional terms. So your buyer can say, and again, this is why you're going to want to work with a lawyer and title company that can draft this language for you. The buyer can say in legally enforceable language that he has waived that right, and in fact does not want to view a property that won't offer money to help his commission that he would otherwise owe or owe his fee. Does that make sense?
Okay, I know.
Does that make sense to you, buddy? Does that make sense to everybody? If that didn't make sense to you, raise.
Yes,
Okay.
thank you.
Okay, any other questions before we move on to, yeah, go ahead.
We have a couple more for Marilyn. So if the seller is willing to pay more than the buyer is agreeing to, can you modify the document?
If the seller is willing to pay more than the buyer, it's going to depend on how the language is written. So we know that some people are going to say in the MLS seller concession, and they'll give a number up to 3%, for an example. And that's going to be their cute way of demonstrating how much they offer in commission. Two things there. If the seller makes that offer on MLS, but the buyer doesn't need it for whatever reason, the seller is still stuck with that commission, that amount. So if you advertise seller's concession up to 3% of the value of the loan, they're going to have to offer that concession across the board. When that happens, if that amount is more than what you agreed to in your buyer's broker agreement, then 2% of that concession can pay you, and the other 1% of that concession has to go to the transaction as a whole. Because remember, you are stuck with what is in your agreement, and you can't be paid any more than that as commission, no matter how much is being offered. Does that make sense? I wish I could see more of your beautiful faces. I would know whether you're learning or not, but I bet you're eating lunch and doing other things. Oh, Gigi, I'm gonna use you as my arbiter of all things good. If you don't understand what I just said, shake your head, okay? And Eileen's there too. Gigi, do you not understand what I just said? Okay, let me say it again. Thank you. This is how I know I'm not made a good explanation. Okay, Gigi, let's talk it through. Let's take the easiest first situation. If you call up Eileen and Eileen says, hey, I'm offering buyers 3% on so-and-so house. If you have, and she says as commission, I'm offering 3% as commission, okay? If your agreement, Gigi, says 2% commission, then that's all you can get. Period, end of discussion, unless there was a bonus amount as well. So the fact that the seller is offering more does not give you the right to take more under any situation. That's when you called Eileen up and she says, we offer 3% commission. Do you understand that part before we go to the next one? Okay. If you want to be a clever listing agent and you want to say seller concessions of 3% of the purchase price, because you're trying to signal to the community that you might be offering commission, the problem is you're going to be stuck with offering that concession across the board, even to people who do not need it. Because that's back to the rule of what has the seller advertised in the MLS. And unless that's negotiated away in the contract, that's what the seller has to pay. And then you would get your 2% and the extra 1% concession they're offering would go to the deal as a whole to help them with their closing costs and all of that. And Armando is going to talk about where you could get in trouble with your ICPs on the lending side, but that's how it works. Do you understand that, Gigi?
Yes, but I have a question to that.
Okay.
So I'm going to show Highland View Circle. And I call Melissa and I say, hey, is your seller offering anything? And she says they're going to offer 2 for the buyer's agent, but I've negotiated 3
Okay.
with the buyer. Okay. Now, what was it?
The buyer has to pay, is responsible for paying 3, period. When that situation, Gigi, the seller's 2% concession or 2% offered commission would give you the first 2%, or that concession of 3% can be applied to what the buyer owes you, but you are still entitled to the amount of the agreement. You can't get more if the seller's offering more, but they have to pay that amount to you, no matter whether the seller is offering commission at no amount or at a lesser amount.
So that was my question, Meredith. There's no way, and ethically you shouldn't, but there's no way that anyone's going to double dip where you're getting 2 from the sellers and 3 from your buyer's agreement.
No, you can't do that. The buyer's agreement is the max you can get, no matter what's being offered.
Okay.
Okay, and with that, I'm going to go back to open houses.
Go for it.
So-
I love answering open houses questions because I think there's been a lot of development of the rules in this.
Well, and the reason I'm saying it is because there are agents who don't want to take time to go to open houses. We'll send an agent and say, hey, swing by, let me know if you like it. I'll write a contract, all that. If someone is showing up at the open house, they do have an agent, but the agent's either too lazy or doesn't want to show up or can't be there. Can we have them sign a broker buyer agreement because their agent is lazy and I am taking my time, even though I'm representing the seller?
You could do that if they would be willing to do it. Now, you have to then act as their realtor, of course. So you take them to the open house or you send them to the open house and say, get me on video. Oh my gosh, look at that big water stain. Oh my gosh, on resale, people don't like the master being upstairs. You're offering broker services, and anytime you do that, you have a right to get an agreement.
And
Is
in that case, you'd be a transaction broker.
That's right. And you could,
Perfect.
right. And that goes to part 2 of that question, Gigi, that I get all the time, which is what happens if I am the listing agent hosting the open house and a buyer comes in, what do I have to do? In this similar answer, if all you're doing is showing that house in the same way that you show it to every single person who comes to the open house, what you're doing then is you're working on behalf of the seller. That's who you're there for. If somebody calls you after the open house and say, hey, I was at your open house and I really like that, I'd like to write an offer. At that point, both NAR and FAR are saying, as long as it's ministerial, filling out that contract, right? The seller's agent can do that without have to have a buyer broker's agreement. And the seller's agent can do that even if the seller has said, I'll give you 3% commission if you sell it to somebody else, and I'll give you 4% if you sell it yourself. Because again, you're working on behalf of the seller. So that would be completely legal and you wouldn't need a buyer's broker agreement. But once you start acting on their behalf throughout the transaction, Gigi, you're ordering inspections for them, you're helping them figure this out, helping them, then you're acting like a realtor. And once you transition to that, you have to have a BBA. But there's nothing that prevents a transaction broker from having a BBA on the property while they have a listing agreement that offers them money on the other side. There's absolutely nothing that prevents that.
Perfect. That was my question.
Yep.
That
Does
was,
everybody understand that? Because I want to make sure we get this straight, because this is going to be a lot, coming up a lot. It's going to be coming up a lot in the context of open houses. And it's going to be coming up a lot when you have those situations where listers are contacted, listing agents are contacted directly.
one more thing tagged onto that.
Yep.
In reference to you saying someone saw the house, they call me, really love your house, want to write a contract. At that point, do I need to create the BBA for them because they've already seen the house, or just act as their realtor?
At that point, what were you doing when they saw the house?
One of us was conducting an open house.
Right. So that's the rule I just said. You can
Okay.
do simple things. You're allowed, the rules specifically say you are allowed to write a contract.
Without the BBA because they came to the open house.
That is correct.
Perfect.
Gigi, as the listing agent, buyers approach you directly, that trying to work through that transaction is really not going to be possible. You're going to have to start helping them choose inspectors and arranging for that and blah,
Right.
blah, blah. At that moment, Gigi, you are acting as a broker's agent and you would have to have a BBA agreement.
Okay. All right.
And again, nothing prevents you from getting paid under your buyer's broker agreement and under your listing agreement.
Okay.
Make sense?
Yes. Now it does.
And yeah, and okay, any other questions? Because these are going to be coming up a lot.
We have another question from Carolina. She says, could you please make a clarification about the MLS link in the realtor's remarks directing to the company website, and then they will see the commission offer for the listing?
Okay, so people have taken the position, this is excellent. A lot of people are going to try to do something like this. Realtor only remarks, click here to determine what we pay. And when they click, they come to let's say a flyer, or they go to the site. That would be a violation because you would be directly advertising the commission in the realtor remarks by the way you said it. Does that make sense? If you just say, come see 123 Main Street and have a link for 123 Main Street, then you can, once they go to 123 Main Street, you can, of course, let them see the advertisement that is on all your listings, that is on your website. So that's why some people have taken this 2-click rule. You have to click on the website, and then that just goes to the Sell State Superior General site. And then you have to click on 123 Main Street. A lot of people are feeling like that is a safer way to prevent you from getting in trouble, and it serves the same purpose. So you can't do something, for example, attach a flyer that shows you offer 3% commission. That's using the MLS to show the commission offer. That's why some people like that 2-click rule. Click for the first time to go to Eileen Skates Realty, and then click again to see 123 Main Street. Does it make sense?
Yes, we got a yes from Carolina. Thank you. And then Liz has a question saying, won't the agreed amount or percentage between the buyer and buyer's, maybe buyer and buyer's agent from this form be reflected on the closing statement and be a part of the amount due by the buyer to close?
Absolutely. These will be sent to title companies just as other agreements if you want to make sure that you're paid. And again, that's another item I would put in the additional terms section if I work with a lawyer or had a broker that worked with a lawyer that could say that correctly. Because remember, they don't have to pay you at closing, but it is due and owing at closing. So it's always a best practice to agree that amount can be shown on the closing statement. The lender has to know about it, and that's the best way for you to be sure you will in fact be paid. Because you send this to a title company, they ain't gonna close it without it showing up on their underwriter is unlikely to let them close it without this showing up. And then it would be paid for differently than what it would be a buyer obligation, not a seller obligation. And then if the seller were offering something, it would show up as a concession on the buyer commission side. So then the net to close would be 2% instead of the 1%, because that 1% that the seller was offering would be applied as a credit and of course taken out of the seller's proceeds. Does that make sense to everybody? If not, we need to ask clarifying questions.
A yes from Carolina that she understands.
Okay.
We do have another question that states from Cassie. These BPAs only apply to residential properties and not commercial properties, correct?
That is correct. The BBA only applies for your typical 1 to 4 that you're aware of, but it does include mobile homes. So your typical, when it gets outside of the 1 to 4 context, this does not apply. That is the official ruling. Does not apply to vacant land, does not apply to commercial property, does not apply to the sale of a business that you're working on for a client. None of that. It only applies to 1 to 4 residential.
Perfect. Jackie has a question that asks, why is there a 3% cap?
There's not. There's no cap. You can say, hey, my client's looking at $5 million properties, and I know I'm going to have to work my ass off to get this thing closed. I know there's going to be a lot of inspections on that big fancy house. I know I'm going to have to go back a lot. I know there's going to be a lot happening. Y'all know. Conversely, you could be working on something that's really cheap, like a mobile home. And similarly, you could have mobile home properties. So you can set, God bless you if you can get somebody to pay you 25%. There is no cap. You just hear us saying 3 because that's the industry standard.
And then looks like Andre asks, will it be legal for a realtor to advertise a very low commission to represent the buyer?
Can a realtor you mean can the lister I don't understand. Can you say I'm only going to do it for $500? Yes. If you're working with a buyer, you can try to get a bunch of deals by saying Camille's going to charge you $3,000. I'll just charge you $500. That's totally legal.
Camille is more expensive than that.
For sure, you're worth it. I was just giving. Was that really the answer to answering your question?
I'm going to see if Andrew can chime in on that because I'm not too sure.
And for sure, there's going to be buyers agents offering to work with buyers for very low percentages, hoping to establish a relationship, catch the client, maybe turning them to a lister later. These are all sales strategies that you guys are going to have to conference together and talk to your broker about. But yeah, there's no minimum and there's no maximum. There has to be some minimum or you don't have an agreement. But if you want to put your minimum at $500, $250, 1%, 15%, you can put whatever in there you can negotiate.
Hope has a question that asks, are there modification forms to use for changes to the agreement?
I haven't seen them. I have not seen an addendum for this yet in your form simplicity.
Yes, there are, Meredith.
Good. Thank you.
there's- There are modification forms for all the different versions. We're talking about the exclusive form, but there are several others, and there are modifications for all of those.
Yeah, and what we're talking about specifically is the exclusive for the transaction brokerage. There's also exclusive for single agency, several different kinds of representation types. And Hope has just told us that the modification or addenda for that are already in form simplicity. Thank you, Hope.
Perfect.
I do want to say, I don't want to leave the call by pointing out they didn't have to do this until the 17th. And I have a opinion that they shouldn't have done it until the 17th, because whether they do it now or the 17th, we still got to work through it. It's going to take a hot minute, and they might have hurt some buyers in the meantime, but they wanted to protect their butt.
We do have a question from Nicole. She asks, back to the discussion of modifying a BVA with an addendum. Isn't there a BVA modification for that? I think it goes into what we were just talking about.
It sounds like Hope answers that question. I will tell you, quite frankly, I have not looked at it, so I cannot express an opinion. But you're going to have your same problem where it's addendum, a modification, the form. You want to be very careful, because remember, you guys are not supposed to be practicing law. And the standard of what requires a lawyer is the same. Would a reasonable, not a reasonable real estate agent, not an accountant that you're working with, but would just the average person understand what you wrote, and would what you wrote do what the parties intended it to do? When you start veering into that section, you're violating the unlicensed practice of law. Addenda are very scary, should be scary for you guys, because it gives you the idea that there's free reign to write there. And I cannot tell you the number of realtors I've seen getting in trouble writing themselves those addendum that they think makes perfect sense, which actually doesn't, and then they can be sued for negligence. And then, of course, if the prosecutor's office was sufficiently motivated, if it was a lot of money or something, they could also face a criminal penalty, not having to do with the buyer's broker agreement, having to do with the principle that you guys are not supposed to be writing things that should be written by a lawyer. The only reason that you're allowed to use these forms at all is because the Florida Bar and the Florida Real Estate Association said, okay, they can use these standard forms, but they have to use these standard forms. You can't go off and write your own contract. Any more questions?
Yes, we have a couple. One from Janelle that says, so as a listing agent, a buyer calls me to see the property. I can show it without getting the BVA signed because I'm representing the seller, ? Only time I would need it signed is if I'm representing the buyer as well as the transaction broker. Or do I need a BVA or showing agreement signed prior to taking a buyer into the home?
So that's going to be the same analysis. So if somebody calls you and they saw a sign, you can do something like send them an MLS flyer. You can send them a video of the house that wasn't made specifically for them. But if you are going to take them in the house, you have to have the buyer's broker agreement. The only reason you don't have to have that as a seller's agent holding an open house is because the buyer has come to the property without your involvement. Once you're involved in getting them to the property, you need a buyer's broker agreement. However, if you are the listing agent, and this again, we've said this a few times, hopefully it'll sink in. If all you're going to do is write a contract for that buyer, he says, I want to make an offer of $1,750. He had seen it on the video, or he had done something without you taking him in the house. Then as the seller's agent, you can do that without a BBA agreement. But anything that starts looking like things that a buyer's broker would do, you have to have a buyer's broker agreement. And I've never seen a transaction broker that's had both sides of the sale not helping the buyer get the deal done, because I don't know how the deal gets done if the buyer doesn't get help, unless the buyer has an attorney or something like that they're working with.
All right, we are getting towards the end of our questions. And one of the last questions here says, if your BBA shows 3%, but seller's paying 2%, can you do modification to BBA to change this to 2% if you have already shown the home and the buyer wants to make an offer?
You sure can. Again, remember, this agreement may be modified at the agent's discretion. Unless the buyer wants to terminate, in which event, again, it is your choice whether they can terminate. And some people will then say you can get out if you want, but you're gonna have to pay a cancellation fee. Yes, you can amend this agreement to say anything different. You can amend it to say they're now willing to pay a bonus, just as long as you're not getting more than the agreement or the amendment to the agreement says.
Perfect. All right. I know we have to get Armando this time as well, so I'll get this last one out with Liz. She says, so we need specific language in the additional terms in order to put this in the packet that goes to the title company, or have it paid at closing, or just as long as it's in the packet that goes to title, it will automatically be a part of the closing statement.
Okay, I really don't understand that question. I can tell you this, if you send this agreement to a title company, I cannot imagine them willing to close without proof that this has been paid, which will be evidenced by the closing statement. Is that your question?
Okay, yes. Liz says yes.
Now, there's nothing that prevents your buyer, if they tell the title company they're going to do this, and if you're amenable, there's nothing wrong with the buyer just writing you a check. Maybe he doesn't want the other side to know what he's paying you. So there's nothing that prevents him from just sending you your own wire and not getting it at closing. You're just prevented by getting more than what the agreement provides. And I will say, I would be very careful at amending an agreement based on a specific property after they've seen it. In other words, you show them a house at Miranda Homes. Miranda girl tells you, you know what? If these folks buy, we have a special deal by the end of the month. We'll give you an extra 500. That starts to look like you're acting against the interest of your buyer because it's specific to the transaction. If you happen to know that Miranda Homes offers $500 for every transaction, then go ahead and put it in there, because it's not going to be paid by the buyer. It's going to be paid by Miranda Homes. And tell them that. Say, I've got a $500 bonus here because that's what Miranda's going to pay if you end up buying this house. No problem at all. All right, so since there's not any questions, the last thing I want to point out before we get to Armando is there was a time, guys, when arbitration was cheaper than litigation and lots of folks would choose it for that reason. That time is gone. Applying the American Arbitration Association rules, I can tell you from personal experience, the litigation is just as expensive. And the problem is, if you lose, there is no appeal. So in my opinion, again, you'll have to follow your broker's direction, but in my experience, I have developed the opinion for my own clients that the ABA arbitration is not the way to go anymore. They have their own expensive pleading sets, and they follow the rules of evidence, which means you have to take depositions, on and on. But nowadays, it is as expensive as litigation. Now, mediation isn't, but arbitration is. All right, Alyssa is going to put my phone number in the chat. This is my cell number. If you have any questions, I don't just help realtors that close with me. I help every single realtor who calls me and needs help, because I believe in you guys. And sorry to the gentleman on this call, but I especially believe in supporting women realtors. This is one of the few ways that women in these days can really build real net worth. And I just love real estate. It's in my bones, in my blood. So she's going to put my number in. Do not be afraid to call me. Please call me before you get in trouble. I don't want you to hire me after you get in trouble. So get a hold of me if you need me via text or phone. Thanks for listening to me. And without further ado, I'm so excited to welcome in Armando to help you understand how this all works with financing. Armando is going to tell you how long he's been in this business. I would guess 30 years, but he'll let you know and give you some stats about him and then answer your questions about what about a financing transaction and what, if any of this money can be added into the loan. Go ahead, Armando.
Meredith, thank you so much. Can you all hear me? Yes.
Yeah.
Perfect. Meredith and Alyssa, thanks for having me on board. Congratulations to everybody here. I know that it can be a little scary, but the best growth happens at moments of inflection like this. Congratulations to you all. Let me just jump in because I know that we're tight on time. Meredith alluded to IPCs. What that stands for is interested party contributions. And in the example Meredith gave, there was, okay, what if the seller is doing a concession? So let's separate that out. A concession is generally going to go for the buyer's closing costs, and a commission is going to go to the buyer's agent. So if you say they're one and the same, then we're doing a disservice to the buyer because the seller concession is capped. For example, and let me just read this real quick. The National Association of Realtors Settlement Agreement does not change the FHA core rules on interested party contribution. That means that FHA is still going to allow up to 6% seller concession towards buyers' costs that they can buy, that can pay for appraisals, title work, anything that's associated with the buyer's cost, all except the down payment. So if we say part of that 6% goes to pay the buyer side, then you're actually limiting how much benefit the buyer can get from that seller concession. The buyer, if the seller is saying we'll pay 3% commission plus 6%, then the seller contribution, then the buyer's actually getting a 9% benefit versus the cap that FHA would say you're only getting 6%.
So
Sorry
Armando,
if I'm
how does
making
that
sense.
work out? Give us a real life example in the transaction of how that would look if you were a seller wanting to offer these concessions.
Okay, so let's say, and let's use a simple number, $100,000. Nothing's available for $100,000, but it's easy numbers, and I'm not that smart. $100,000, and I'm saying, you know what? I'm willing to pay a buyer agent 3%. That's $3,000. In addition to that, I'm willing to pay 6% towards the buyer's costs. That's another $6,000 that can go again towards the title work, appraisal, anything I want. So I'm actually giving the buyer a benefit of 9%, $9,000 versus, okay, I'm going to do a total seller concession of, let's say it's an FHA loan, and each agency has different limits. So FHA allows up to 6, so 6% all in, and 2%, and the buyer says, I want to give 2% out to my buyer. Okay, that leaves you only 1% towards actually getting your title work done. So at the end of the day,
What if a buyer wants to do that? Chooses and in writing confirms that I understand there's some kind of rule as so long as it is customary or something like that.
Right. So we haven't had any tests, but if the buyer says, hey, the seller's offering 3% concession and I want to give that concession to my buyer's representative, we'll give it a go. It may work, but again, at the end of the day, we're limiting how much benefit the buyer can get because that commission can be negotiated directly with the listing side, and still the seller can still give the buyer an additional 6%. So sure, we can absolutely give it a go. I would argue that's not the best course of action, but sure, we can absolutely try.
And I think that operative language is so long as it's customary in the community. And the question is, how soon is it no longer going to be customary in the community? And what we're hoping is that FHA will have FHA, Freddie, Fannie, and VA will have a new rule as a result of all this. But right now there is nothing, right?
No, at this point, it's too early, as you say. We'll see, things will become clearer as we look back at what worked and what didn't. But again, I think this is a wonderful opportunity for transparency. So although it's uncomfortable, I think it's a good thing. In 2008, 2009, the lending side went through it with Dodd-Frank, and we were all concerned, oh my gosh, we're not going to be able to make a living here, but we made it through and it's all good. So gang, it'll be fine. It'll be fine.
And then when you're getting a pre-qualification for someone, and they've told you that they have this 3% agreement. And are we allowed then to talk to you, Armando, and say, hey, is he gonna have enough cash to pay my 3%? Is that something you could share with us under that portion of the contract that says we can get information from the broker?
I've not had that experience. Obviously, it hasn't come around.
Not yet.
The so the I promise you quick response, full transparency, and quick closings. If you call me and say, hey, Armando, do these folks have the wherewithal and the capacity to pay me? I'm happy to say yes or no. I can't go into more detailed information because that violates some of the privacy rules that I'm bound to. But I'm happy to give you an indication of, yes, you're working with a great buyer, put them in your car and show them homes, or, hey, we need to do a little work before you start exerting effort. So that's my commitment.
That's an excellent answer. Do you see any chatter about changing the rules yet? With it not chatter from lending agents, but chatter from the agencies? And I wonder how the Department of Justice position might influence whether they're going to give us some help or not. And I wonder if that's what they're waiting for.
So far, the information I'm getting is all the agencies is taking a wait and see position. What I can share with you is that in our world, you can depend on us for stability. We're going to get your deal financed. Merideth is going to get your deal closed. If we do what we're supposed to do, again, act within the law, be transparent, we're all going to be fine. I honestly think that this is a good opportunity to shine and show our buyers what we're worth and that we're on their side.
Yeah, and one thing that I will tell you about Armando is he is going to tell you whether these folks can close or not. It's not like a typical lender who just listens to how much they make per month and then sends a pre-qual letter. He will not let you waste your time with people that are not going to be able to buy the house because he wants to earn your business and he doesn't want to waste the time of his potential clients. Instead, what he does with those folks is help them understand how they can get themselves in either a credit or a cash position to be able to actually get the loan that they're looking for. And that's one of the things I love the most about working with Armando is if he tells you it can close, it's going to close. And if he tells you it can't close, it can't close. So you better wait until some work gets done. Armando, people are wanting to have your contact information. So if you could put that in the chat, please, that would be great. And remind everybody how long you've been doing this.
So even though I don't look it, I've been doing this for 30 years, 5 years in Massachusetts, 25 years in Central Florida. I've loved working with Merideth and her team and her family. It's been a wonderful pleasure. And I've worked with some of you in the past as well. Thank you for that opportunity.
Here's always the question, Armando. Can you finance mobile homes?
Absolutely, yes.
Yay! Do they have to be a certain age or younger?
76 was the rule. Yeah, younger than 1976 is generally the rule. I'll share with you that I'm very bullish on manufactured homes because they offer one of the only opportunities for affordability in this market. And yes, the answer is yes. We can do FHA loans. And here's something to think about. We can actually do financing for someone that buys a lot and puts a new manufactured home on it. It's considered construction, but that's a very reasonable option. So yes, the answer is we absolutely do manufacture homes.
What about if they buy vacant land and want to bring their old mobile to that land? Can they still do it?
I can look for lenders, and here's the cool thing. I'm a broker, so I work with lots and lots of lenders. So I will find an option. I am aware that we can do new manufactured home, meaning I bought the land and I brought in a new manufactured home. Those are pretty simple to do. An existing one, I'll research. I don't know.
Yeah, it doesn't happen that often. Also, can you do tiny homes?
As long as the loan meets Fannie, Freddie, FHA guidelines, the answer is yes.
Do you think can you see why a tiny home wouldn't as opposed to a manufactured home?
If it's not anchored down, I've seen some tiny homes that are on wheels that are akin to a vehicle. Those I doubt will get approved.
But the kind that people are liking now that are actually built into the ground.
I believe so. Yeah. So FHA has there are some minimum square footage rules. I want to say it might be 500 square feet. I think FHA has minimum square footage rules, but as long as they fit the agency guidelines, sure. And then again,
Little
there's also
answer,
some,
yeah.
yeah.
Excellent. All right, we've got some questions for you.
Yay.
Do you work with any foreign nationals and do you do cash outs for foreign nationals?
The answer is yes. We do foreign national, cash out for foreign national. We can also do, yes.
Okay, and from the lender side, what would you expect the compensation to look like on the closing statement? Or do you even
So
care?
we really don't care.
Because what
Thank
I
you.
think you're gonna see, this is what I think you're gonna see, Armando, see if this makes sense to you. There's gonna be a buyer charge of, like all the other buyer charges, just like their title, just like their closing fee, da, da, da. There'll be a buyer's charge of, say, $3,000 payable to Gigi.
Mhm.
And then you're gonna see a seller credit on the other side, just like you see the other seller's credits. That's gonna be 3% to buyer for commission. And then the settlement statement at the bottom is gonna look the same as the regular, it's just the side of the transaction it's on. And of course, the cash to close for the buyer is gonna be higher on the buyer side, but it won't really because it'll get a credit from the seller side.
The seller, exactly. And the settlement statements is something that you do beautifully. I trust
y'all
in
don't
what
care.
I trust in what you do. And when we sit down and analyze a client and say, yes, you're ready to go find a home, my assumption is that the commission is going to mostly come from the seller side. I anticipate that's still where the bulk of the commissions are going to come. Every so often we'll see some one where the buyer is actually taking money out of pocket and paying for it. Especially first-time home buyers, they're putting together
Hurts
nickels.
the worst people. This hurts
Yeah.
worst people. It hurts
Agreed.
VA buyers, it hurts FHI buyers, first-time home buyers. This was actually a terrible decision for buyers, but that's the bull's already out of the gate on that one. Okay, I have another question for you, Armando. Will you keep us updated? The minute you hear of updates, if you'll reach out to me, we will do this again because I am predicting, guys, that there's going to be lots of movement. FAR and NAR are going to come out with more of their FAQs. We're going to be addressing issues as they come. Stay tuned. We mean it when we say we're having a new presentation on new stuff.
Wonderful. Absolutely. Yes. Let me know what person you'd like for me to share it with. And as soon as I have anything that's
Melissa,
newsworthy,
we'll do it right away. We might even not wait till Monday because we want to be breaking news on these issues. People need to know somebody that they can rely on to get this information.
you got it. We'll do.
Marilyn asks about VA concessions and closing costs. Right now, there's not been a change in the VA position, correct?
Correct. It's similar to FHA. VA allows up to 4% seller concession towards buyer costs. That hasn't changed.
We hope. Eileen says, I thought a moved mobile could no longer be financed. You might be right. Armando said he's never really seen it, but he'll look into it.
Sure.
So Gigi says, so if no seller compensation, the compensation will be total debit to the buyer. Yes, because the buyers that'll be included in the buyer's cash to close. And when Armando is qualifying people, he's going to make sure that they do have the cash to close even without a seller concession, because you can't guarantee that, guys. They could fall in love with a property that's out on the market and they don't have the seller paying any. So you need to work with a lender that's going to assure you that they're qualified to buy even with this obligation if they get no concession from that. And Armando is that type of lender. He knows.
Agreed.
Yeah, and it's a windfall basically if they get the seller to pay some of it. And I think maybe at the beginning, we're going to see a lot of sellers not offering, but pretty soon they're going to realize that they're not getting the traffic on their listings that they'd like to see. And their agent will point that out while making clear that there is no requirement to pay commission. Realtors don't get in trouble here. You need to make it very clear that there is no obligation under any circumstances to pay commission. But sellers are going to find out pretty quickly that without an offer of some compensation on their side, they're not going to get many showings of their property. Also, remember, you cannot just show properties that offer a concession. The settlement agreement says that. If your buyers don't want to look at something that doesn't offer a concession, that needs to be in your additional terms section. And then here's a question for you, Armando, just to confirm, if only 4% for VA and FHA max for buyer is agent getting 3, is 1% seller concession? I don't
I'm
understand.
sorry, I don't understand the
that
question.
question. I guess what she's saying
I
is,
wrote it wrong.
go ahead, Gigi,
Yeah.
ask it.
If a
Beth.
4% is max for VA and FHA.
If
But-
FHA 6%.
FH is 6% up to 6% concession?
Yes.
What about Fannie and Freddie, Armando?
It's on a sliding scale from 3 to 9%, depending on the down payment.
Okay.
Everybody
So,
write that down. Everybody write that down right now.
right.
Little notepad, because this is gonna come up, and if you forget, you can call Armando and he'll
There
remind you.
you go. There you go.
If it is VA offering only up to 3%, but my value is 3%, then there's no room for a buyer concession from the seller, right?
Unless they offer it separately.
Yeah, correct. So if the seller says, hey, I'm paying a commission, and again, I understand, here's my understanding, and correct me, Meredith, that you cannot advertise the fact that a seller's paying a commission, but it's still communication. If you pick up the phone and say, hey, are you paying a buyer side commission? Yes, we're paying 2% or 3%. Oh, and are you also offering a seller concession? VA allows 4%. Now the seller is paying your commission at whatever it is, 2-3%, plus if on VA, 4% concession towards buyer
Okay.
cost.
So it would have to be two separate transactions per se. To offer me a percentage and offer them up to what is legally allowed by yeah.
So VA will say, okay, you can get up to 4% seller concession towards the buyer costs, which include title work, appraisal,
Right.
whatever.
And then on top of that, I'll pay an additional 3% for the buyer broker agreement.
Correct.
Or
That is
for
correct.
okay.
Yes, you
But
got it. You got
only-
it, Gigi.
Let's clarify, Armando, so long only as the government considers seller payment of commission to be the regular in the area.
And at this point, that is our interpretation, and we will see how that pans out.
See how long that it takes to, because it's really not normal anymore. Meredith,
Over and
am I
above
right?
that,
Shouldn't we be
Uh,
trying to get the buyers used to paying compensation rather than always considering concessions? In time to come, won't buyers be paying their side of the compensation? The reason that we keep, yes, of course, it would be very best if they can pay it for themselves and then get all the concessions for themselves. That's the best option. But we all know for first-time home buyers, FHA home buyers, it's going to be difficult to come up with the cash. So that's why we keep talking about concessions, because some of us, we could come cash. And in fact, what you'll see for, let's be honest, for some of your wealthier clients, they're going to be marketed hard by buyer's agents who want more money and will tell us that they work in luxury properties and they provide this great service. And so we're all going to be fine. The people that are going to be hurt, and the ones that we're talking about here, are FHA buyers, VA buyers, people without a lot of cash. First-time buyers generally don't have cash. Armando, they want your phone number, buddy.
Yeah, I'll put it in the sections. It's 407-733-0752. Again, 407-733-0752. And I'll share my contact information with Alyssa, my email address and website. So I'm
Say
so
it one
grateful
more
for this
time so I
opportunity.
can put it in the chat, Armando. 407.
407-733-0752.
Wonderful. And remember, Armando's not just here because his knowledge on this subject, he's here because this is a guy that will get your deal closed. If it's closable, he'll close it. If it's not closable, he'll tell you so you do not waste your time.
That's my promise.
So I have a question that maybe it goes back to the FHA VA. So if the max on FHA is 6% concession in the past, so doesn't it go back to the listing agreement? Because currently we're getting paid by the seller on the listing agreement. It's going to the buyer's broker. So if that's still the case, because we can still list property and offer it to a buyer's broker. If that's the case, and they offer the 3% concession to pay for your fee, and it goes to the buyer's broker, you can still offer the full 6% to the buyer.
Right.
So it depends on what the listing agreement says then. Because isn't that the same, Meredith, like what we do now? Because the listing agreement offers it two different ways. The seller can offer to pay the buyer broker direct, the buyer, whatever, they can do the concession. But it's not really, the seller's paying it directly instead of through the broker. Like a la EXP, what they've said is they're recommending that they don't co-broke. But there's two lines on a listing agreement that allow it to be paid either to the buyer's broker and they're going to co-op, or the seller's going to pay the buyer's agent stuff directly from the seller. Does it matter?
Okay, so I don't really understand what you said about what EXP is requiring. Can you repeat?
Well, EXP said that they're recommending, and they're actually redlining out the section of the listing agreement that says that the buyer, that the seller will pay to the buyer, to the broker. I'd have to look at the listing agreement to read it exactly, but there's two sections now in the new listing agreement, and they're recommending that you line that out. And they're recommending to all of their agents to not do it that way and to only allow the seller to pay it directly to the buyer.
As I said, when I say frequently, when I get on these things, I am not your broker. I'm not anyone's broker. So you always follow the direction of your broker. Now, if your broker had called me and asked that question, I would not have given that advice.
So the new listing agreements have two lines for compensation.
That's why I would feel comfortable. The new listing agreement is been formulated by people who have done nothing but study the settlement and try to figure out what's allowed and what's not allowed. So that's why I wouldn't do it. But perhaps your broker just doesn't want to even potentially get in any trouble. That's why you got to do what your broker tells you to do, because they.
Well, this is irregardless of what my broker says or doesn't say. I'm just trying.
I wouldn't do that, Hope. I wouldn't do it, Hope. I would, if I was working with a lister, I would absolutely tell them, in my experience, you don't have to offer compensation. You don't have to, you don't have to, you don't have to. You're going to say that about 15 times to protect yourself. But then I would say it's unlikely that we'll get as much traffic as we want if we don't offer something. And then maybe you start them out or maybe they don't do it right, want to do it right away. They think their house is gorgeous and it's just going to sell. Like everybody thinks their house is gorgeous. But then you say to them, hey, we haven't gotten much traction here. Let's go back to that listing agreement and go ahead and agree to pay the buyer some commission. But you don't have to pay, remember everything. You don't have to pay anything. That's going to have to precede every statement you guys make. The last thing I'm going to say before I let everybody go. FREC and FAR have both taken the position that they will not be in the business of enforcing this rule. What they have said is the only way you could get quote unquote caught by not using this form is if your file was audited in the normal way, and just if they find you didn't do a right form there, that's how it would come up. MLS has taken the position that they have the ability to reach out to you guys and get copies of these agreements to make sure that they're there. That's MLS doing that as a result of your membership in MLS. So I think that's ridiculous. I think they'll quit when they realize that they don't have the staff and that it takes too long, but who knows? I also want to tell you, don't forget, these are not state laws. These are not national laws. These are rules that only apply to people who participate in the MLS or are otherwise members of FAR or NAR. Lots of agents have told me that they are ditching this whole thing entirely. They don't see any value in MLS anymore. They don't want to pay all that money. So they gone. So if those realtors are not realtors anymore and just become agents, none of these rules apply to them. So you might very well be not having these agreements and all of that because they think this is burdensome and they don't want to do it. So remember, this only applies, not state or federal law. It only applies to members of FAR or NAR or MLS. All right, you have my number. Here is Armando's number. And if anybody wants to reach out to Alyssa, did you put your email in the chat?
I'll do it right now.
Okay, if you want to reach out to Alyssa at this email, she will send you a copy of this marked up BBA so that you can refer to it and refresh your mind on some of the things that we talked about. You can also call the office at this number, which I'm going to put in here, and any of our numbers available on our concierge website or our legacy legal team website.
And if you put your name or email in the chat already, I have it down and I will send it to you already.
All right, thank you guys. Thank you, Armando.
Thank
And-
you for having me. Take
And
care,
you can
gang.
be assured that that Armando and I will be on it, white on rice, and we will be showing up as soon as there is something new to show up and talk about. Thank you, Armando.
My pleasure. Thank you for having us. Thank you, Alyssa. Thank you, Meredith. Have a wonderful day, y'all.
Thanks,
Thank you.
everybody. I'm going to
Bye.
leave the room. Thank you, Armando. I'm going to leave the room open. Everybody can jump out that wants to, but I'm going to leave the room open for just a minute in case you need to put in your email here or you want to get any of our contact information. Thank you, Armando.
Thank
You're
you.
aging so beautifully. It's just not fair.
You're wonderful. I appreciate you. Thank you. You look gorgeous too.
Tell Miss Phil Mary that I love her to the moon and back.
I promise I will. I'm heading up to Massachusetts to see my kids tomorrow morning.
Do you know that your rock star daughter reached out to me recently out of the blue?
Oh, how wonderful. No, I didn't know.
Tell her that it made my heart sing.
Will do. Will do. God bless you. Take care.
Bye-bye. I'm just gonna leave it open a little bit longer, guys, in case anybody needs to put in their email or pick up this in their email. Thanks, everybody, for listening. I know it was a lot to listen to, but I hope it was helpful. And we'll keep having these, you know, FAR is gonna be coming out with more and more rules and interpretations, as will NAR, so we're on top of it, and as soon as there's something new to share, we will have it right here. I'll take a last minute to pitch the quality of closing with a title company that's owned by an attorney. I'm not an underwriter, I'm the actual attorney that's available in the file to help you solve any problems. Of course, if you need legal assistance to solve a problem, we will give you 3 names. But if you choose to work with us, whether it's probate, boundary line disputes, easements, finding errors, whatever happens in the file, we understand it and we can get it done quickly for the same price as a quote unquote regular title company. So do consider using us if you haven't. We would be thrilled if you would just give us a chance. And I'm certain if you tried us once, you'll never leave. All right, I'm going to count to, we're going to wait for 30 more seconds and then we're going to be out of here. And thank all you guys for hanging in. And Armando does financing obviously everywhere. So he has not only Lake Sumter, Seminole, the villages, all of it. Yeah, Carolina, I'd be glad to have that conversation with you. You need to call, get a hold of Alyssa and she'll put you in contact with my scheduling team. Takes a village to raise me around here. Don't know what I would do without my people, my humans that are wonderful. All right, we're out. Thank you guys so much. Have a great day. Kill it out there. Bye.